how it is that we are where we're at, why you got that letter, why you maybe didn't get the letter, but why it's important that you are aware of what the water court is considering. This thing, I'm going to set my stuff down here. I'm going to set it here. That'll come over here. Sorry about that. If I were to answer how we got where we're at, in my own words, just summarizing it, I would say it ties back to this gentleman's prayer. We have been wallowing in a society that has embraced secular intellectual and moral relativism where there is no right and no wrong, and therefore there is no definition, clear definition. There's an evolving definition of ethics, justice, and law. And I would submit to you, and by the way, I appreciate your prayer, sir. I would submit to you that this compact is a culmination of basically absolute arbitrariness. All of the historical documents and history, in my view, were either ignored or rejected by the commission. So let me get into the details. Am I holding this too close, or is that all right? That's fine. In 1979, the Montana legislature created the Federal Reserve Water Rights Compact Commission. Why did they do that? Because in 1908, there was a Supreme Court ruling called the Winters decision that had to do with water for a tribal Indian reservation in Montana, the Fort Belknap. And the issue was, what water did the tribe have there? So the Winters decision, in a nutshell, determined that the federal government, when it set aside specific enclaves of property or reserved land like Indian reservations, impliedly reserved enough water to fulfill the purpose of that reservation. Impliedly, because it wasn't explicit. So the Montana legislature created the Reserve Water Rights Compact Commission to negotiate these reserved rights. Under the Winters Doctrine itself, there's two important words that you need to understand. Number one is federal reserved water rights. And number two is the purpose for which the reservation was reserved, okay? So the Reserve Water Rights Compact Commission negotiated this settlement over a number of years. And early on, this is a commission of 10 or 12, somewhere in there, some legislators, some individuals appointed by the governor. They negotiate on behalf of the governor. And in early on in the negotiations, the commission rejected the notion that of off-reservation water rights and what's called the Unitary Management Ordinance that creates an entirely different administration process within the boundaries of the reservation. In short, it removes those tax-paying citizens of Montana who live within the boundaries of the reservation from the same administrative process established by Article 9 in the Montana Constitution that applies to those citizens outside of the reservation. So I'm hoping that just right there you would see immediately an issue with equal protection. For some reason or another, the Compact Commission changed their mind by 2012 and said, yes, we'll accept the assumptions of the tribe and the federal government that all of the water within the boundaries of the reservation belongs to the tribe, and that essentially those individuals that live within the boundaries of the reservation, including non-members, are living on what was intended to be a permanent homeland for the tribes. So the contrast was the purpose of the treaty for assimilation purposes, or was it indeed for the purposes of a permanent homeland for the tribe? Very significant difference there. So the Compact Commission submitted that to the legislature, and in 2013, it was sponsored by a Democrat legislator out of Bozeman, and we were able to beat it back. It was controversial, as it should be. So we stopped it the first time that any reserved water rights compact was rejected in the legislature of the many that they've done. So they resubmitted it in 2015. Some of the intrigue, and I'll try to touch on some of that without exposing my indignation and disdain too much. They decided for sure that they had to have a Republican sponsor of the bill with the Republican majority, and they needed to have a handful of Republicans join with the Democrats to pass it. So they got Senator Chad Vincent from Libby to sponsor the bill. They changed some would say changed, some would say violated the rules of the House. Anytime in the House of Representatives that a bill is tabled in the committee, in order to bring that bill to the House floor, it takes a 3/5 vote. That's just out of respect for the work of the committee, and it makes sense. The committee hears the bill, they hear the testimony, they have more understanding. Well, they got a rule change to allow for what they call the silver bullet idea, and they decided to give the minority party a certain number of silver bullets where they could blast these bills out of committee, that's the term, with a simple majority rather than a 3/5 vote. And they were able to do that. The committee, well, I'm not going to get into those details. There was other shenanigans behind that. They got enough handful of Republicans to join with the Democrats, and it passed out of the House barely, 53 to 47. And that was in 2015. Jumping ahead, this has to be ratified by the legislature and the Congress. Senator Tester eventually introduced legislation to ratify it. In the Congress, his bill basically laid there and didn't get acted on. It had a $2.3 billion price tag as a settlement to the tribes. And by the way, the state of Montana was going to contribute $55 million. When I asked why, the only answer I could get, well, the federal government requires a state contribution. So that bill didn't go anywhere, mostly because of the cost. And then in 2020, Senator Daines, again, we have to get a Republican sponsor because we've got a Republican administration and others. Senator Daines, believe it or not, introduced this bill, Senate S3019, and it sat without any action for quite a while. It never had a committee hearing in the House of Representatives. It never had a standalone vote in the House of Representatives or the Senate. And after the 2020 election, Senator Daines and Mr. Gianforte were able to attach it to the omnibus spending bill during the lame duck session of 2020. They attached it to that huge bill, 2,000 and somewhere around 2,200 page bill, and it passed with this so-called must-pass bill. So that's how this act was ratified, quote unquote, and why we're where we're at today in that sense. Quickly, I would like to just cover some of the misconceptions that were very frustrating for me as this whole process took place. It was obvious to me that the Compact Commission was not aware of the history of the reservation or the background. And I don't know if you have a packet. I think the gals took a copy of some of the acts that are applicable. But the premise of the Daines bill and the compact is that the permanent homeland premise is that there should have never been homesteading there by non-Indians, and the idea of allotment, which is giving individual land to individual Indians, violated the treaty. But if you have that paper, the fact of the matter is that Article 6 of the Hellgate Treaty authorized allotment and sale of the residue of the land. You can see the language there. If not, you can look up Article 6 of the Hellgate Treaty. I forgot my glasses, Kate. Would you hand them to me? One of the problems is that this is an Isaac Stevens treaty, and he didn't put all of the details in Article 6. He just said, as provided in the 6th article of the Treaty of the Omahas. Well, so you have to go to the 6th article of the Treaty with the Omahas, but let me read this. This is just an excerpt. The residue of the land hereby reserved after all of the Indian persons or families shall have assigned to them permanent homes may be sold for their benefit under such laws, rules, and regulations as may after be prescribed by the Congress of the President of the United States. So, to me, that language is clear, and it indicates to me that the purpose of the treaty was assimilation and not permanent homeland. One of the problems with the compact is it doesn't recognize the diminishment of the reservation. And if you do have that paper, here's how the compact defines Flathead Indian Reservation. Flathead Indian Reservation is all land within the exterior boundaries of the Indian Reservation established under the July 16, 1855 Treaty of Hellgate, notwithstanding the issuance of any patents and including rights-of-way running through the reservation. So every square inch of land is still considered reservation land under this compact. And in response to our equal protection arguments then, our Attorney General at that time, Mr. Fox, his office told us that, well, you're not similarly situated for purposes of water administration. Well, I find that quite interesting because I'm similarly situated with those outside the reservation insofar as the state of Montana taxing my property, but the rest of the Montana Constitution doesn't apply to me. Now, then this would be the same situation for you folks in Sanders County that are within the boundaries of the reservation. You're under the UMO and the exclusive jurisdiction of this Flathead Water Management Board that's appointed by the tribe and the governor. If you haven't been watching, that board has been appointed. Another interesting part that I focused on was in the Enabling Act for Montana and the 1889 Enabling Act for statehood. The language was that all lands owned or held by any Indian or Indian tribes shall remain under the absolute jurisdiction of the Congress of the United States. That language was incorporated and is currently part of Article 1 of the Montana Constitution. So again, my point is, the state of Montana is taxing my property. The state of Montana is applying its laws to me and my property. So it certainly, my property is not under the absolute jurisdiction and control of the Congress, like tribal trust land is. And so, obviously, my property can't be part of the reservation. So just that in itself is a double-minded policy. So, and in that, I included in that paper the Article 9 language that establishes the administrative process for water rights. Article 9, Section 3 of the Montana Constitution is very specific about the duty of the legislature to administer water, and yet they have removed, in the words of Chris Treaton, the chairman of the Reserve Water Rights Compact Commission, they have removed those citizens within the boundaries of the reservation that hold private property and are state citizens from the control and protections of the Montana Constitution. He called it the grand bargain.